The chair.
Attorney General, you ready?
Yes, sir.
Okay, so we are on Clause 11.
Clause 11.
The question is that Clause 11 stand part of the bill. Honorable Senators, Senator Mark?
Yeah. Mr. Chairman, under Clause 11, there is an area that we have some. No, I think Clause 11 seemed to be okay with me.
Okay,
Yeah.
all right. So the question is that Clause 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 11 now stands part of the bill.
Clause 12.
The question is that Clause 12 stand part of the bill.
Mr. Chair, the government proposes that Clause 12 be deleted for the reasons discussed relative to Clause 10. This is a recommendation which comes from the government itself. No stakeholder or senator has spoken on this issue, but we believe that we should remove the option of the Registrar General to have a role to deregister whilst there is an ongoing process at the FIU. So we prefer to take this clause out entirely.
Okay. The question is that Clause 12 be amended as circulated. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 12 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 12 as amended now stands part of the bill.
Clause 13.
Honorable Senators, the question is that Clause 13 stand part of the bill. Senator Mark?
Yeah, Mr. Chairman, in Clause 13, again, we would like to submit that whilst it is noble for us to have a provision where once your registration is refused, you may appeal the decision of a judge to a judge in the High Court. And of course, that would be subject to a process, of course, that would follow. What we would like to record here, Mr. Chairman, is that for many non-profit organizations, this is a very expensive, costly, and time-consuming exercise. And Mr. Chairman, as you are aware, our court system is based and is experiencing right now heavy backlog of cases. So that to put a non-profit organization to line up in a matter of this nature, we believe that this is a very punitive, onerous exercise. And I think that the Attorney General should take a page out of the Charities Act of 2011 of the United Kingdom, where, Mr. Chairman, a tribunal has been established for this purpose, so that ordinary NGOs, when they are faced with certain challenges, they do not have to pay lawyers to go and appear for them at the High Court level. You can have, for instance, yourself or somebody who has some experience going before a tribunal. So I am suggesting, rather than we subject these NGOs to a judge in the High Court, could the Attorney General consider establishing a provision for a tribunal to be established where it would be less costly, less time-consuming, and it would give these organizations a greater degree of flexibility in doing their work? That is my submission, Mr. Chairman.
Senator Timal.
Yes, Chairman, during my contribution to the debate, I did raise this matter in terms of my concern is more particularly for the small, what I refer to as the small to medium-sized NGOs, operating, with budgets that could be, couple $100,000 or less. And this, it's good that there is grounds for appeal, but or means for appeal, but it may well be beyond the means of a significant number of small to medium-sized NGOs. And I'm not sure how we can address that. Maybe the AG could take it into consideration.
Thank you. I thank honorable senators for their considerations. We certainly do intend in a separate piece of law, which we have undertaken to draft together with the nonprofit sector and the network of entities that comprise that, a larger piece of legislation which would more than likely, I think quite prudently, have tribunal-type arrangements. Tribunal-type arrangements are deceiving in the sense that people believe that they're not costly. The cost is certainly not the judge or the tribunal, it's the representation. And insofar as in tribunals we build in the right to appear by counsel, 6 a dozen of one, half a dozen of the other, but it gets worse, because in the tribunal context, you actually have your ultimate appeal from the tribunal going to the court anyway. So you're putting in one layer of equal expense, which is the tribunal, because it's the lawyers that cost. And then you're going to a second layer of expense, which is the High Court, all the way up to Privy Council. So you've got 2 sets of expenses. It was one of the mischiefs identified in arbitration and mediation. And until we had quarter-next mediation to remove the cost of the mediator, that's only when fees started to crawl down. So sounds good, Tribunal sounds good. But until you get a lawyer to tell you, I ain't charging you, then you're not out of the bamboo. So we do think that the argument is one to be had depending upon structures. I'm not so concerned about the capacity. The civil law capacity in the courts are being well managed. Cases are down to 1 year in trial, if so long at all. We've managed to crack the backlog considerations. There's almost a 90% disposition rate in the courts, etc. Where we had problem was in the criminal justice arena. Fortunately, this government has done a lot in that area, and we're headed in the right direction. So quite respectfully, may I say that it is important to have an appellate route. There is no better way to do that when you're treating with potential property than by way of due process. This is how you clothe this thing in proportionality. And may I respectfully at this stage decline the invitation to construct a tribunal arrangement.
Okay. Senator Vera.
Thank you, Chair. My area is ADR, Alternative Dispute Resolution. And so we're always looking at ways in which you could resolve disputes outside of the strictures of a court. We've looked at tribunals long and hard, for example, in sports, copyright and intellectual property. We've looked at models in Kenya and all over the world. But as the AG says, it's an expensive undertaking. First of all, Who will man the tribunals? Where will you cite your tribunals? You will have to have rules and procedures for the tribunals. You will have to have staffing for the tribunals. And at the end of the day, people are still going to go with lawyers and argue them vigorously, just as though you're going before a court. Now, you have tribunals, for example, in the industrial court where you have panels of 3, but that is a whole system, that's a whole ecosystem. So while it's attractive, I think the compromise that was reached arising out of the debate, because it was just originally just judge in chamber, the appeal to the judge. But by having the first round, by going to the registrar general or the registrar directly, and then having the appeal, I think makes sense. Maybe down the road, there can be a tribunal for all these other things, but for this specific legislation, you'd have to have a specific tribunal with alternates to deal just with this. And it might not be not cost effective, but the time is going to take for implementation as well as something we would need to be mindful of.
All right. So, honorable members, the question is that clause 13 now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 13 now stands part of the bill.
Clause 14.
Honorable Senators, the question is that clause 14 stand part of the bill. Attorney General.
Mr. Chair, the government proposes that clause 14 be amended specifically and quite simply to delete subclause 2. One of the representatives for the NGOs pointed out in our consultation between the House of Representatives and here that this could potentially be difficult, and we want to agree with her. She pointed out in particular the obligation to have a disclosure which at any time is accurate was something that was probably even a higher standard than clause 15. And we think that there's great prudence in that recommendation. And in those circumstances, we propose to delete subclause 2 and to renumber, of course, by removing the reference to a subclause 1. Those are the proposals for our recommendations in this clause. I know that Senator Drayton has a proposal for clause 14. And we actually agree to it. Yes.
Senator Drayton's.
So that would be, if I could be so bold, Senator Drayton, thank you again. Subclause D as proposed by Senator Drayton was that it be amended. D right now says non-monetary transactions as may be prescribed by the regulations. And what we think is prudent there is non-monetary transactions of property as may be prescribed by the regulations.
Okay, so I will now put the question first on Senator Drayton's. I assume Senator Drayton has nothing to say because it's agreed upon, right? So I'll now put the question first on Senator Drayton's amendment and then subsequently on the Attorney General's amendment. The question is that clause 14 be amended as circulated by Senator Drayton. Those in favor say aye. Aye. Those against say no. I think the ayes have it. So the question is that clause 14 also be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Honorable Senators, the question is that clause 14 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 14 as amended now stands part of the bill.
Clause 15.
Honorable Senators, the question is that clause 15 stand part of the bill. The question is that clause 15 now stand part of the bill. Those in favor say aye.
Sorry,
Those
please,
against
before you do, we had said we were going to revisit the 10 million, 15.1, a gross annual income exceeding $10 million.
Yeah, I think that, yes, we did. Thank
Yes,
you. And I missed it because Senator Richards is temporarily out of the chamber.
I am in agreement that 10 million is very high. That's approximately $850,000 a month passing through your organization, and you don't have to audit. I was thinking probably something like down, I would say about 5.
If I could say why
or
we thought
2
10.
to 5.
So we debated this quite strenuously at the cabinet level, and it was, in fact, the Minister of Finance who suggested the 10 million. And in his rationale put forward, because we were potentially dealing with property as well, meaning asset, physical land, etc., a bus that is donated, we thought that that number could trip up quite quickly. The second thing is, because we haven't yet gotten into the risk basing, which the FIU is going to do after it collects this list and then goes ahead, we thought it prudent to allow that opportunity to happen first. Under 14, everybody has to keep records, so the records are going to be there. Under 15, you're keeping records and you have to audit them. So we thought it prudent to start a little bit high. Let's gauge the industry. Let's see where the parameters are. And then as the industry's compliance comes into purpose and education and outreach happens, we then are able to look at where the ceilings really ought to be. So we didn't want to unwittingly go too low. So we preferred to go a little bit higher in this matrix, knowing that this is an issue which you're going to have to come back to as a country quite soon. Obviously, this law is not intended to be proclaimed until there is a significant amount of education, outreach, massage. Again, for the record, we give the commitment that we are going to plug into the network of NGOs, have their feedback on the legislation as proposed. We're separating out this particular law from the other legal purposes that we will look to develop as a grouping, and then to come back. So that was the government's rationale for the 10.
Senator Binka?
Thanks, Chair. 10 million should be okay, because at the end of the day, there are organizations that perform, that have a throughput in terms of funds of 3 million and 5 million, and really the margins are insignificant. The issue that I would have is how is this 10 million looked at? Is it, because 1 year an NGO can have let's say they build houses and they can have 30 million passing through, and the next year or the next couple of years, because they're basically looking at disbursing and raising funds again, they may have less than $1 million passing through, so, and then may not be able to pay for audited accounts, which is very expensive. So I don't know if you can treat with that as well.
So it is as set out, it's with a gross annual income, so it's a year-to-year position. What I know happens is that these entities tend to, when they reach a particular critical mass, they tend to do these accounts anyway, because the vast majority of contributions which feed entities of this type result in them having to have audited financials anyway. So I don't think it should be so much of a difficulty. It is technically a year-by-year basis, and it's 10 million for that year. If you're below that year, you can safely argue, look, I'm below 10 million and it doesn't apply to me. But you'd find that the funders usually require that you do that.
Senator Mark?
Yeah, I just, Mr. Chairman, show you. Under 15.1, we have this 10 million, but under 15.2, this is applying to all NGOs, meaning that they have to complete an audit of their financial accounts, or is this related only to those NGOs exceeding 10 million? Or am I to read it separately?
It's the latter. So 15.2 is in the context of 15.1. 15.1 only applies if you're over the 10 million mark.
Okay.
Yeah, so anybody who's under the 10 million complies with 14, not 15.
Okay, all right, cool.
Yeah?
Senator Drayton?
Thank you, Chair. Attorney General, quick question about 15.5 in the definition of a qualified auditor. What if an MPO has an auditor outside of Trinidad and Tobago? Does that still apply, or how would that work?
Fortunately, we have one of the best here in the Senate, Senator Drayton. There's Senator West, who's on the bench here. Perhaps she could lend us a hand from her perspective in having worked in this area. It really is intended that you're qualified within the meanings of the IFRS positions, etc. But I think the question is the territoriality.
Yes, what happens is that when you have a situation that would usually be an international organization, their main auditors would prepare the accounts, but you'd have to have somebody local certify that it is in accordance with our IFRS rules.
Senator Vera?
Yeah, we also have ICAT, and they have rules and regulations about who can give audited accounts in this jurisdiction. So I expect that.
Senator Hussain?
Very much, Chair. Through you to the Honorable Attorney General, AGI noticed that we have stated the NPOs that will be liable to file the audited accounts. Now, is there a date in which these NGOs are obliged to file these accounts? Because I didn't see whether or not the date, because when you look at the Companies Act, companies have to file within a certain date. Is it that we're going to prescribe something similar? Because right now it's a bit vague in terms of the date in which these NGOs are obliged to file by.
Sure. IFRS catches that. And just like the Companies Act, you file on the anniversary of your incorporation. So everybody's date is different under the Companies Act. So we didn't intend to use that sort of formula. The IFRS will catch that in its circle as to what the NGO, the MPO's financial year end is and how accounts go, etc. So that's left up to the IFRS standards.
And those directions will be given to the RG from the IFRS in terms of the date.
The RG has
the RG does have
no position other than, so an NPO with a gross annual income shall have the obligation to audit. Upon completion of an audit, the financial account and records of the NPO, a qualified auditor shall submit his report to a controller of the nonprofit. A controller of the nonprofit shall submit the audit to the RG when requested by the RG. So what this was really done, the right of audit that the FIU is going to do, that's where the in tandem between the FIU and the RG comes about. So the FIU would tell the RG, call for that report. And what it is that entity would have a continuing obligation to produce reports, but not necessarily file it on a continuous basis.
But AG, what I'm seeing is that that position, the latter position is stated for FIU calling on the RG is in subclause 4, right? When we look at subclause 3, the one you just read, is that the RG does have the power to call on the NPO for audited accounts. And because we don't have a date, I'm asking whether or not the IFRS standards will guide the RG also, because
I follow your question now.
Regulations, maybe that may be captured under the subsidiary legislation.
Yeah, I follow what you're saying now. Thanks for the clarification. And yes, it will be the regs. So the IFRS will say in what cycle they are to do their own business from their financial year-end perspective. When that is produced, the regs under the law will say to the RG how and when you call for what, and then the FIU has its independent focus.
Because we need to know the date in which the financial year starts. Because when I look
Senator, if I were to ask you, sorry to interrupt, what specifically is the amendment you're asking for?
No, I'm asking for some clarification with this particular provision, because when I looked at the definition of a financial year, it doesn't give a specific start date, whether or not it's from January to December.
And it won't, because each entity will be different. So
each financial year would be different.
Correct. We don't know. It's the same way each annual return is filed at a different date, because the Companies Act doesn't say that. It just says you file it on the anniversary of your incorporation or continuance.
Okay.
Right.
All right.
Honorable Senators, the question is that clause 15 now stand part of the bill. Those in favor say aye. Those against say no. I think the ayes have it. Clause 15 now stands part of the bill.
Clause 16.
Honorable Senators, the question is that clause 16 stands part of the bill. The question is that clause 16 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 16 now stands part of the bill.
Clause 17.
Honorable Senators, the question is that clause 17 stands part of the bill. Attorney General.
Mr. Chair, we propose that we delete clause 17, which provides for an offence, and we replace it instead with the provision of an administrative fine, which is in keeping with section 516A of the Companies Act, And we've actually used the same terminology from that, which is where a controller fails to notify the RG in accordance with Section 16, the RG is entitled to collect from the controller a penalty of $300 for every month or part thereof that the controller fails to notify the Registrar General.
Senator Mark?
Yeah, Mr. Chair. I think that the Attorney General should try to, if he can use that same approach as it relates to other provisions, because I've seen that that is a remarkable alteration on his part to deal with administrative penalties rather than fining and jailing. So I was wondering if this is a procedure that he can follow as we get into the offences section. I think that's a very important step that we should look at as we proceed.
Chair, just
Senator Remy, Dylan
yes,
Remy?
yes, it was back to not clause 16. AG, do you have to? This says that you have to submit to the RG any changes within 30 days of such a change. Do you still have to submit annual, let's say annual returns, or no, you don't?
No, the companies registered under the Companies Act, the non-profit companies, will still have to submit annual returns, yes. So
Okay.
remember, there are different types of NPOs, one species of which is the not-for-profit companies registered under Part 5 of the Companies Act. Under the Companies Act, they are required to fill and to file an annual return. It's called the Form 29, and that's done on the anniversary of its incorporation or continuance.
What would that mean for that company as
It-
far as this is concerned, this
All right.
clause 16?
So the controller of non-profit companies who fall under the provisions of the Companies Act, they continue to be governed by the requirement to file their annual returns.
And therefore, they don't have to submit within 30 days of a change, because they would submit that when they submit it yearly.
So let's hold on. And this particular clause 16 now, 16 is tied into clause 5.4. And clause 5.4 in this bill is where we put the obligation. It's to be found at page 7 of the bill. 5.4, this is the form containing name, address, declaration, name, occupation, copies, etc., etc. If any of these particulars which are filed, which are referred to here in 5.4 change, all NPOs, including NPOs which are companies under the provisions of the Companies Act, have to file within 30 days.
So therefore, a question remains. That means that the non-profit companies have to file twice?
Yeah, they'll
The
be filing
changes twice?
two separate documents.
Okay.
Yeah, under two different regimes, because the Companies Act still applies.
Okay.
Mr. Chairman, after.
Members, just to indicate that we are on clause 17 and you're asking questions on clause 16, the procedure does allow for any comments to be made on a particular clause at a particular point in time. So we are on clause 17 as it is right now, and we are trying to dispense with that clause. Clause 16 has already been put to the question and now stands part of the bill. So we're on clause 17, not to derail Attorney General. You've made the necessary comments in relation to your amendments on clause 17?
Yes, sir.
Good. So Senator Mark, on clause 17? Yes.
Mr. Chair.
He made his comments already. I took note of them.
No, I'm
Senator
just.
Mark, yes, he asked me to look at this applied approach throughout the rest of the offences, and I listened.
All right.
no,
So is there
no.
anything new to
No,
add,
no,
Senator
no.
Mark,
No,
to
no.
that?
Yeah, this is why I'm intervening, so I don't
Okay,
understand.
okay. No, Mr.
Did I say something that was wrong?
This is
Okay,
a
I
democracy, you
understand.
know.
No need
Okay.
to get worked up. Just add your comments so that we can keep the procedure moving as smoothly as we've been doing. Go ahead.
Thus far. Yeah, Mr. Chairman, what I was about to ask the Attorney General is that this amendment to clause 17 that is in circulation now. Is it the same provision that is applicable to companies for profits when they fail to submit their annual returns? Are they subject to the same $300?
The answer is yes. It was amended in the year 2012 by one Larry Hawaii, Minister of Finance under the UNC government.
Mr. Chairman, what I'm saying is these are non-profit organizations. And I don't think that we have to be slavishly following amendments that would have done in 2012. This is not a profit organization or company. This is a non-profit organization. So I find it very punitive, right, to impose on a non-profit organization in the event of they forgetting, Mr. Chairman, to file their financial statement with or their annual returns to the Registrar General's office. They are going to be called upon to pay $300, and every month or part thereof, they are to pay that $300 if they fail to notify the registrar. How can we equate a company for profit for a company that is not making profit and impose this kind of fee? So, Mr. Chairman, I think this is too onerous, it's too oppressive, and I call on the Attorney General to reconsider that matter in terms of this amount of fees that we are imposing on a non-profit organization.
So, Senator Mark, just as a point of clarification, as far as I've understood it, so the Attorney General would have spoken to the reason for moving this amendment. You would have responded by endorsing that.
Yep.
And now you're saying that you're not endorsing that.
No, I'm saying the fee is too onerous. So, in other words, it's not a question about not paying. But why $300? I'm saying,
right.
why not say $100? Why not say $50?
We got it. So,
Why
Attorney
have-
General,
why
any specific response to that?
Harmonizing it with the Companies Act, and it's been in application.
Okay. All right. So the question is that clause 17 be amended as circulated by the Attorney General. Those in favor say aye.
Aye.
Those against say no.
No.
I think the ayes have it. Honorable Senators, the question is that clause 17 as amended now stand part of the bill. Those in favor say aye. Those against say no.
No.
I think the ayes have it. Clause 17 as amended now stands part of the bill.
Clause 18.
Honorable Senators, the question is that clause 18 stands part of the bill. Attorney General?
Mr. Chair, we believe that we ought to put in a qualification to the mens rea, the mental intention to cause this trigger. As stated, we have clause 18 simply going a non-profit organization which does certain things shall, and then when we get down to the actual penalty, we then provide for it, which seemingly doesn't take care of the willfully or knowingly or without justified cause doing something. Now, the truth is that the company's registry, which is run by the Registrar General, which is now going to be with a new registry for non-profit organizations, so they're two separate registries, that actually has a system of querying. So when you file a document at the company's registry, they issue a system of queries, they send you a notice, they say you need to amend this appears to be inconsistent, etc. So taking into account those things, we thought it prudent to amend this clause by adding in the qualification that you must knowingly and without reasonable cause do something before you trip the offense. We think that this would allow for some more latitude. In particular, Ms. Lioto, who I recognize is here, had raised the submission across coming together with other members of the NPO sector and said that, look, we want to take care of the categories of entities that don't have sufficient education or understanding, and they may have a legitimate or just cause for doing these things. So that's the rationale for this amendment.
Senator Mark?
Question.
We completely reject this amendment and the entire provision. We believe this is oppressive, it is absolutely unnecessary, and we believe it's an invasion of the rights of persons to property, which is guaranteed under Section 4 and 5 of our Constitution. This is one of the most contentious parts of the legislation, among other parts that we are heading to. So we want to say very clearly and plainly that Clause 18 is unacceptable, unsatisfactory, and it really compromises the rights of those non-profit organizations to determine how they are going to treat with property. And there's an invasion here by the government through the Registrar General and somebody calling themselves the receiver. I do not know where to get that power from, to tell an NGO or NPO how they must distribute their business. That is totally unacceptable. So we reject out of hand that entire provision.
Attorney General, any final
Yes,
statements?
Mr. Chair, I just would like to just put onto the record that to say that this clause is unreasonable and to be rejected is to firstly reject the whole principle of voluntary surrender. This clause is about voluntary surrender. So if the UNC's position is that people can't voluntarily surrender or end their pursuit of being a non-profit organization, well then so be it. That's the UNC's perspective. The second aspect is Clause 18 says a non-profit organization which wishes to voluntarily surrender or is no longer in operation shall notify. RG receives the notice, he may approve the surrender. Within 6 months after receiving approval to surrender, a non-profit organization shall distribute its property in accordance with 21. It has the discretion to distribute its property, Mr. Chairman. When we get to subclause 4, the contravention of subclauses 3 and 4, which is what we're dealing with by adding in a wider range of treatment with a qualification to the mens rea. What we're doing here is we're protecting this thing in a much greater way. So I respectfully reject the arguments offered by my learned friend, Mr. Mark, Senator Mark, and for the reasons adumbrated.
Honourable Senators, the question is that Clause 18 be amended as circulated by the Attorney General. Those in favour say aye. Aye. Those.
I have a question on the, who knowingly and without reasonable cause, who makes that call?
A court.
A court?
So to trip an offense, you have to get to court. To be guilty of an offense after a trial, a judge would hear, look, I'm hearing a matter that you breached Section 18 of of the non-profit organizations law. If you get that far as to actually have an offense offered against you that takes you to court, it's a court who listens to the factors. Well, tell us why. It isn't a strict liability that it just happened. It's not like possession of drugs, where because you had the cannabis on you, you're guilty and your intention is irrelevant. Here we provide for the first element of a crime, that is the mental intention to commit a crime, to be widened. And here we say, look, you have an exculpation, you have a defense, if you had a reasonable cause for what you did. Look, we sent in the certificate with John Brown, and John Brown got sick, or we gave it to our lawyer, and the lawyer had a fire, or the lawyer died. I mean, there are all sorts of reasons that the court has come to recognize as reasonable cause in these circumstances. I hope that assists.
Okay. Senator Vera.
And just to add to that, the burden of proof is on the prosecution. So it will be the prosecution that will have to prove knowing relating to actual knowledge. That is to say that the defendant knew of the circumstances which made his actions an offense. And so again, the decision maker here is going to be a court, and the burden of proof will be on the prosecution.
Thank you.
Okay. The question is that Clause 18 be amended as circulated. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honourable Senators, the question is that Clause 18 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 18 as amended now stands part of the bill.
Clause 19.
Honourable Senators, the question is that Clause 19 stands part of the bill. Attorney General?
Mr. Chairman, we propose an amendment to Clause 19 to add some more due processing in. We thought it prudent to have a new subclause 3 added into the bill, and we also thought it prudent, exactly as we just did to Clause 18, to provide for a specific type of mental intention element to a potential offense. Firstly, we say in the insertion, we provide that in the obligation to keep records, which is what Clause 19 is about, we're saying, first, subclause 1, the controller shall ensure that the records are kept, the following records, and it's listed there. Subclause 2, a non-profit organization shall retain these records for specific periods of time. We've harmonized it to 6 years, which is what the taxation requirements are in this country. And then we say, by way of an insertion as circulated, where the regulator, that's the FIU, in exercising its powers under Section 18G of the FIU Act, determines that a non-profit organization is not keeping the records required under this section, it shall issue a notice to the non-profit organization requiring it to provide the records within such time as the regulator determines. So we thought it imprudent to let the NPO sector have the benefit of a knock on the door, a notice from the regulator, who's the FIU, saying, please produce your records, and then after that, move into the cycle of considering an offense. But specifically here, we say, if you've contravened an offense, put the qualification that you must knowingly and without reasonable cause have done that. We didn't get the notice, we moved office, it was never served upon us, we did certain things that are exculpatory in nature, and as Senator Vera quite properly put it, to trip an offense, it's the burden on the prosecutor to prove beyond reasonable doubt certain things. That would be the elements of knowledge and the lack of reasonable cause.
Senator Mark?
This provision, which gives the regulator, which is the FIU, what is called arbitrary power to determine things as it relates to notice, totally unacceptable. We are dealing with law, and we need to be a little more certain and specific. You cannot give the regulator this wide power to determine when, what is the time frame? We don't know. And this is too much power in the hands of the regulator. So this is open for favoritism, Mr. Chairman. Big organization might get away. Small organization, giving the government trouble, they might crush them. So you need to have equality of treatment in this arrangement. And I'm not seeing it. And worse, Mr. Chairman, when you go to the provision subsection 3, you have a fine of what? $50,000 and 7 years. Why doesn't the AG deal only with administrative penalties and impose a fine and not a jail term?
Mr. Chair? AG? First of all, arbitrariness is just not even on the table. We have specified here that the FIU is acting pursuant to the FIU Act. We've said which section in the FIU Act. That's prescriptive, which is the opposite of arbitrary. So I don't know where that comes from, quite frankly. And I'm going to try my best to be as polite as I can. Secondly, there must be a line drawn in the sand as to when something is serious enough to be an offense or not. Provision of notice in the manner that we're doing is an amplification of due process, Mr. Vice President, Mr. Chairman, and therefore I most respectfully do not accept the propositions offered by Senator Mark.
Okay. Honorable Senators, the question is that Clause 19 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Honorable Senators, the question is that Clause 19 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 19 as amended now stands part of the bill.
Clause 20.
Honorable Senators, the question is that Clause 20 stands part of the bill. Attorney General?
Mr. Chairman, there was a considerable amount of discussion as to what disqualification should look like under the provisions of this law. And there was a very compelling argument that including disqualification on the basis of a conviction, as the bill had pointed out here, in 20 subclause B, being guilty of a criminal offense which carries a penalty of a term of imprisonment of 3 years or more, that would be unduly restrictive. In fact, even outside of the Senate, the many representatives of the NGOs raised the issue, and they pointed out to the very proper position that NGOs include, for instance, if you're looking at those engaged in recidivism management, reformation, etc., they may very well include people who are in fact offenders and who are best suited for this purpose. We think that there's great merit in that argument. Therefore, we propose the deletion of B, 20B. And what we have proposed by way of that which is circulated is we've gone back to the formula that is used in the Companies Act. One, that you should be a person over 18 years of age, 18 years and over. Two, if you're mentally ill within the meaning of the Mental Health Act, that you should not be permitted, and if you're an undischarged bankrupt. And then we propose to keep the things which treat with terrorist financing and money laundering, which is as set out at A, breaches of a finding of guilt under the Proceeds of Crime Act or the Anti-Terrorism Act, a sentence of imprisonment involving fraud or dishonesty, largely because you're treating with trustee-type relationships here, and if you're a designated individual under Section 22B of the Anti-Terrorism Act and the Economic Sanctions Act, and if you're found guilty of an offense under this act. So that encapsulates the rationale for the government treating with this. I know that there has been a discussion as to the mental health issue. In fact, I want to thank Mr. Robinson from CAISO for his inquiries in relation to the mental health element, citing that there are people who are functional, notwithstanding mental issues, but I don't think that they fall within the category of treatment of certification under the Mental Health Act. So we are dealing, after all, with entities that handle money and that handle certain aspects, and we have been advised to keep it within the parameters of the mental health legislation.
Senator Mark?
Yeah, this provision, especially 20E, Mr. Chairman, where if a person is found guilty of an offense under this act, of course, the person shall be disqualified from acting as a controller. And you have many offenses outside of the main ones that have been outlined. I'm wondering if the AG doesn't want to delete 8E as well, because the main criminal provisions would be anti-terrorism and fraud.
AG?
As well as, before you're talking about proceeds of crime, in A, you have Anti-Terrorism Act, in A as well, and these are serious offenses. But when you put a catch-all is found guilty of an offense under this act, I don't understand why we are deleting B, which I could understand, to allow other people to get out of this thing and rehabilitation to take place. But we are keeping E.
Mr. Chair, I get the point. Please.
Just let Senator Vera have comments.
I don't think this section is referring to administrative offenses, but to criminal offenses. And the criminal offenses are set out at Part 4, and they're very specific. Soliciting or causing to solicit contributions whilst not registered, knowingly or recklessly making or providing a false document, financial accounts or records, and the like. So
these things.
AG?
Mr. Chair, I thank Senator Mark for his contribution and for the offer of caution. We respectfully believe that compliance with the Act should be a mandatory feature of disqualification, and I respectfully decline his invitation.
Senator Richards.
Thank you, Chair, through you to the AG. In the issue of the offender who has served his or her time and is now considered eligible to run an NGO, is there a qualifier with a certain time having passed and someone determining that this person is not likely to reoffend?
No, you mean for an offense under the Act?
Yeah.
In the context of the last one?
Yeah.
No, the standard route of having to go for a pardon would apply. That's the process under our laws. The Mercy Committee, Pardons Committee sits pursuant to the constitutional arrangements, and that's where we continue to reside. And as a member of that committee, I can tell you that we receive applications on a constant basis to clean people's records all the time, and they're dealt with.
Okay, thank you. And sorry, just one more comment in terms of the concerns that some persons had advocated in terms of persons who may be mentally ill but functional, unable to run an NGO or participate in an NGO. Is there any qualifying that as to the functionality of the person, and who makes that determination?
Under the provisions of the Mental Health Act, there would be certification under that act as to whether you're mentally incompetent. Now remember, it's not as if you're walking around with a certificate to that effect anyway. Somebody's got to take a positive step against you to bring you under the provisions of the Mental Health Act. You may very well be prone to long talk, walking in crooked lines, contradicting yourself, all sorts of things which may cause a rational person to question your mental capacity. But if you did a search on the record to see if that person had found themselves under a certification under the Mental Health Act, as much as you would want that to be the case, chances are it's not going to be.
Senator Vera.
Yeah, just to add, there is a presumption of mental capacity, and it's a court that determines whether a person is mentally competent or not even the psychiatrist. The other point that you raised about the convictions being spent, plea bargaining and community service orders allow, if in circumstances that after you've been found guilty and you've purged yourself, that the conviction could be struck from the records.
Senator Mean, you had something to say?
Thank you, Senator Vera.
My point was made by Vera in terms of the court declaring a person mentally competent or not. My question also I also want to raise a concern in that even if a person is declared mentally incompetent, there are instances where people remain on treatment and their capacity to function is reinstated, so to speak. So this is an area I want to express caution, and I understand the Attorney General indicating that he wants to be guided by the Mental Health Act. But it is an area, particularly because I know that there are NGOs and NPOs who are advocates for people with mental challenge. Well, I should say mental health challenges, and very often they themselves have experienced mental health issues. And in that area, you don't want to eliminate people who have mental health issues from serving. So perhaps that is an area that we could have some more consultations, apart from the NPOs themselves, the professionals, to consult with the Attorney General's office and have their input and their recommendation based on a scientific perspective.
I think Senator Amin's contribution is extremely sensible, and I welcome it. It certainly is something that ought to happen. I don't feel equipped to make that decision here today as to where or how one draws the line, and I didn't understand that Senator Amin was even saying that. So I welcome the suggestion from Senator Amin and will certainly take it on board immediately.
I wanted to support Senator Amin because the solution might be not to use the words mentally ill, but is declared mentally incompetent, because you could be bipolar, you could have a depression, and be still compos mentis. On the other hand, if you are mentally incompetent because dementia, Alzheimer's, or one of those, then certainly you should not be allowed to serve.
I lifted for now from the exact version from the Companies Act, so I kept it in harmony with that. But I do think it's a very interesting and important issue. I think Senator Amin hit the nail on the head in saying it the way that she did. It certainly is something that Mr. Robinson from CAISO raised it with us by way of an email correspondence today. So the sector is already thinking about it, and we will certainly get to work on it.
Okay. Honorable Senators, the question is that clause 20 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Honorable Senators, the question is that clause 20 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 20 as amended now stands part of the bill.
Clause 21.
Honorable Senators, the question is that clause 21 stands part of the bill. Senator Mark.
Yeah, Mr. Chairman, we do not believe a non-profit organization should be bureaucratically regulated and controlled by the state. And if we have a non-profit organization and we are winding up voluntarily, our obligation is to simply inform the state. But this application to the official receiver into this and granting approval, this is a kind of process that is unnecessary, it is arbitrary, it is unconstitutional, it is unlawful, it is infringing and breaching sections 4 and 5 of the Constitution as it relates to the enjoyment of property rights, and therefore, under no circumstances can we associate ourselves with this clause.
Attorney General.
Let me try to find the list of words to describe everything in the opposite of the manner that was just used by Senator Mark. It is lawful, it is proportionate, there is ample precedent, it is continuously used, it is a feature of good proportionality, but more than that, Mr. Chairman, Clause 21 says, the organization itself will decide what it wants to do. But the organization doesn't have the capacity at law to handle the distribution. And therefore, we use a functionary who is a chief legal officer under the provisions of the laws of Trinidad and Tobago. That is the official receiver described as the chief state solicitor. That entity is appointed pursuant to the Judicial and Legal Services Commission's obligations to choose that person, and there's an entrenchment of that functionality. It is that receiver that lifts the cost of transferring property, because we're not saying go to a lawyer, have a lawyer pay fees, have a lawyer charge you for these matters. We're using the state services to cause the conveyancing and distribution mechanisms in a manner that has been tried and tested for years under the laws of Trinidad and Tobago. So I wholeheartedly reject the summation of Senator Mark's argument. Senator Vera.
Okay. Senator Vera.
Yeah, and it's a standard feature, whether it is nonprofits under the Companies Act or with charities that, in the case of a winding up or dissolution, that the proceeds would go to a similar type body. And what I understand this section to be saying is that you may have designated a similar type body, but just get the approval to make sure that it is a body that falls within the purview of this legislation and the other parameters. So I don't see anything objectionable there.
The question is that clause 21 now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 21 now stands part of the bill.
Clause 22.
Honorable Senators, the question is that clause 22 stand part of the bill. Attorney General.
Mr. Chairman, we propose some tidying up of the language in subclause 1 to clause 22. We're just reorganizing. Instead of using the phrase shall be forfeited in accordance with, we say shall be treated in accordance with the forfeiture provisions. It would just read in a smoother fashion as it relates to the Proceeds of Crime Act and the Anti-Terrorism Act. Clause 22 treats with forfeiture of property upon cancellation. In subclause 2, we propose that we effectively just delete the reference to G, by just confining ourselves to the reference to subclause F. And that's obviously because we deleted G previously. So it's a consequential amendment.
Mark?
Mr. Chairman, this is absolutely extensive incursions into property rights by the Attorney General, and we do not believe that the Attorney General should be involved in this exercise of forfeiting property in the way that this provision outlines. And we believe that, again, is unhealthy, is unconstitutional. It violates property rights under the Constitution, and therefore we cannot associate ourselves with this provision, Mr. Chairman. So we reject this provision.
Senator Vera?
No, forfeiture does seem onerous, but it is a regular feature in many laws in this jurisdiction. For example, under the Trademarks Act, seized goods can be taken and forfeited by the comptroller. Under the Copyright Act, there's forfeiture provisions. Under the Trade Descriptions Act, there are forfeiture provisions. Under the Customs Act, again, very important powers in relation to seizure and forfeiture of infringing goods. So this is not a novel provision.
Thank you for the assistance, Senator Vera. Pardon? For the record, just simply reject the argument as put by Senator Mark. Just as simple as that. It's just incorrect.
Members, all right. Yes, I know. Okay, that's fine. Senator Mark, you don't always have to have the final say, eh? I know, but I am the chair, let me have the final say. And my final say is, the question is that clause 22 be amended as circulated by the Attorney General. Those in favor say aye.
Chair.
Chair.
Oh, right. Senator Drayton, my apologies.
That's 22,
You have an
no?
amendment.
We're on 22, Chair? Not so? Yes. So, subparagraph 2, I was suggesting to replace shall with may, that the Attorney General may make an application. I'm not too sure if that's appropriate legalese, and probably see clarification there. Given that you may want to give time for an MPO to get its books in order, Attorney General. No?
Mr. Chair, we can easily agree to the recommendation.
Okay, thank you.
So the question is that clause 22 be amended as circulated by Senator Drayton. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 22 also be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Honorable Senators, the question is that clause 22 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 22 as amended now stands part of the bill.
Yeah, clause 23.
Honorable Senators, the question is that clause 23 stands part of the bill. Attorney General.
Mr. Chair, we propose again a specific amplification of the mental intention to commit a crime by putting in the phrase who without reasonable cause into the body of clause 23. Clause 23 is the non-solicitation of public funds. It might very well be in this universe of non-profit organizations that someone may have the need for a defense that they just simply didn't know certain aspects or couldn't comply with it from a strict point of view. So we think it important to relax the provisions of this clause by loosening the mental intention requirement.
The question,
Sorry, forgive me, I forgot to look at the other bit. We're also proposing, this is a very important one, the NGO sector raised, in particular Ms. Roberta Clark, she raised a very important point. What about people who can find themselves caught by non-solicitation, but they really don't want to be in the NPO dance at all? They're just doing a one-off event. So we have proposed the insertion of a new subclause 3. This section shall not apply to a person or group of persons who carry out a single event to raise funds for charitable purposes. Now, there's a discussion afoot as to, and this came from Ms. Clark again, what about an enlarged period of saying, look, people ought to be permitted to solicit funds, for example, as came to us for a 2-year period, whilst they decided if they were going to be in the dance. We actually took several stabs at drafting that, but didn't come up with any legislative precision. And that was very complicated because if we tried to attach it to a person, then you could sidestep the law entirely. If you said, look, the law shall not apply to a person who is soliciting funds for a period of 2 years prior to registration, what happens if you just keep changing people? So it's John today, Jane tomorrow, X the day after, Y the day after. That was issue number 1. Pardon? Yeah, so we're looking at whether NGOs should have a period to solicit before they become registered. That's the issue. One of the legislative treatments, and in fact Senator Drayton had proposed in some of his circulated comments, let a person have that facility. But then if you had a concert of people, then they just keep changing people. And then you could go ad infinitum. The other factor that we had was if we required somebody to give notice of the start date, because where does the 2-year period start from? How do you prove that that person has actually been in the dance for 2 years and not 10 years? So it was a very it's a nice thought, but to get the legislative precision seems to be quite difficult, at least for now. So we're thinking about it. We have not come up with a formula yet. I think this is one of the things that we're going to have a feedback from the network of NGOs on. So certainly when we go into the consultative positions with them, we're going to try to map out how this works. Do we have, look, I want to get in the dance, so I'll file a notice, and then the 2 years starts? But then if you're going to file the notice, what about somebody who didn't know they should file a notice? Do you provide an offense for that? So I think that this is something that will come about through some exploration with the network of NGOs and our drafters. And what we'll do is we'll go to the experts that assisted us at the UK's charities and other entities to see how to manage that process.
Richards. Thank you. And just for clarity, AG, through you, Mr. Chair, and this is for any person/entity raising funds for a cause not unto themselves. I see this as very problematic if it's not resolved assiduously. For several persons who over decades in this country have found themselves and their families in challenges and now will be out in a kind of limbo legally.
Which is why we put the specific language. This section, the whole section, shall not, that is offenses, shall not apply to a person or group of persons who carry out a single event to raise funds for charitable purposes. You see, there's also a significant thing in Trinidad and Tobago, the institutionalized person who you meet on the same corner or outside the grocery door with the same list, collecting and soliciting money for a supposed purpose, etc.
And I appreciate that. Sorry to interrupt you, but
no,
through
not at
you,
all.
Mr. Chair, I know of a person right now whose husband has been diagnosed with cancer, who has put on several barbecues and events.
But those people are not caught in the definition of an NPO, so let's start there.
Okay.
They are not an entity which is a trustee type of relationship that has a body of members engaged in a practice which is for their pecuniary gain other than for reasonable expenses. That's in the definition section. So the cake sale person, the raising money for the amputee, somebody who has cancer going ahead, a child who's in a sick condition, none of those people fall within the definition of NPOs.
As you said earlier, this is being broadcast, so for public ease.
Oh, I appreciate it, Senator Richards. Thank you so much for allowing me to get that on the record through your interrogation.
Senator Hussain.
Thank you very much. Now, the new subsection that the AG is replacing 3 with, the tail end of it is for charitable purposes, in terms of groups soliciting for charitable purposes or individuals. Now, I want to ask the Attorney General whether or not it might be prudent in order for us to create a definition for charitable purposes, because I know that the Minister of Finance does have some discretion where, for example, tax breaks, when a group is defined as for the purpose of charity, sorry.
Mr. Chair, that's a very sensible inquiry. But so the charitable purpose, as it falls under firstly being listed and having the status of a charity, falls under specific legislation and falls under 19th century case law, which the BIR is guided by. So that is an application for charitable purpose to an entity, in this case here, the Board of Inland Revenue, and then the recommendations that flow pursuant to the corporation taxes and the Board of Inland Revenue regimes that apply there. In this context here, we're reliant upon the plain and ordinary meaning of charitable purpose, and that is intended to provide the broadest form of exculpation here. Again, I'd like to remind, we do not intend, until we get the feedback on this very important issue, to be getting into this dance. And if necessary, I want to remind, look, a worst case scenario, if you're proclaiming after everybody has scrubbed it and said, look, we're good with it, is that you partially proclaim. You can always leave a section out entirely, as we do all the time. So the criminal division law is entirely proclaimed except for one section, the registrar of the magistracy, because that has to be worked out in a particular point. So there's a lot of room in the response mechanisms to get this right.
Senator Hussain.
Also, AG, what I was also contemplating are situations in which, because we're now regulating the entire industry, what about groups, for example, who would like to now come and say, well, this week we're going to sell cakes or whatever, and then next week they do it again. And so they use this provision in order to escape the entire regime, but they continue to do repeated charitable exercises.
Very good point. Very good point.
How are we going to treat with that?
Well, it's the same argument we have in how we get people to pay VAT, how we get them to pay taxes, how we get them to register. There is a genuine issue in this country as to that. I mean, there are lots of businesses that should be paying VAT and don't. And there are lots of businesses that should be self-assessed and paying PAY. It'll ultimately come to the level of sophistication in society as it rolls out. So you're right, Senator Hussain. There are gaps inside of this, as there will be in any law.
Senator Vera.
I just want to lend my support to both Senator Richards and to Senator Hussain, because this aspect about people and groups of people coming together to help other people who are in need, I think is a very significant part of this whole debate.
Absolutely.
And, you know, as a lawyer, we could look at it and we could see a definition and say, well, it's not spelled out there, so you are not included. But that doesn't give comfort to the average person.
Yeah.
I think it really should be writ large and clear. And in the part about a group of persons who carry out a single event, that definition of what single event means can be problematic, because people may be doing multiple different things for the same cause or purpose. So
I agree, and let me perhaps do it this way so that the Committee of Undertakings gets this one, because I want to give people the comfort. I agree with Senator Vera, Senator Richards, with the network of NGOs. Senator Hussain brought some very sensible perspectives in his contribution just a short while ago. We do not intend, under any circumstances, to proclaim this law, as and until we have gone into a deeper form of consultation and we have gotten the feedback from the network of NGOs and the state entities too, because the Board of Inland Revenue is necessary, the FIU is necessary, etc. And this is something which could mean the lifeblood of certain things. So we certainly recognize and accept that.
I just want to, at this juncture, ask through you, Madam, Mr. Chair, to the Attorney General. On several occasions, you indicated that you will not proclaim the act. Does the requirement, the CFATF requirement, will it be met if you pass the act but you don't proclaim it and
Yes.
it's not operational, it's
Yes.
not functional?
Yes, let me tell you why. Specifically because we have done the risk assessment in identifying the numbers, bodies, etc., across the platform, which is why we can speak with precision about the numbers that we know about for now. Secondly, because we are involved in legislation which meets for technical compliance. But thirdly, the continuation of the exercise prior to consultation, prior to proclamation via consultation, feeds from your effectiveness, your immediate outcome perspective, whether your law is being applied, because what it does is it addresses the risk factor by getting into deeper analysis. So we will be compliant from that perspective.
Okay. Honorable Senators, the question is that Clause 23 be amended as circulated by the Attorney General. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Honorable Senators, the question is that Clause 23 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 23 as amended now stands part of the bill. Okay. Well, at this point, honorable members, clauses 24 to 27 have not been circulated by way of written amendment. So let me just ask, in the interest of time and ease and process going forward, if anybody has comments between clauses 23 to 27. Yes, Senator Vera. Okay, let me. Yeah, before you put the comments, let me just put the question.
Clause 24.
Clause 20. Honorable Senators, the question is that Clause 24 stand part of the bill. Senator Obika.
Thank you, Mr. Chair. The issue that I have with Clause 24 is that it serves to be a catch-all. And even notwithstanding the Attorney General's submission that they're going to put in a part in one of the prior clauses where persons have a one-time event is not going to be caught under that particular clause. But Clause 24 says once they contravene any part of this entire bill, then they can still catch you, right? I have fundamental issue with this clause in its entirety because of that.
Attorney General?
This clause is necessary. You have to draw a line on what is law and what is not, and what is a penalty and what is not. If we separate out the fact that, okay, I understand that the UNC's position is that they support nothing in this bill. That's been made clear on the collection of voices every single time.
I think that's a mark of disrespect. The Attorney General should apologize for that.
Okay, Mr. Chair, I'm just stating a matter of fact.
It is wholly disrespectful to this entire process to state
Mr. Chair,
that.
just shouting at me is not going to
AG,
change.
okay.
Yeah,
All
may
right,
I just finish my submission?
I'm not shouting,
second.
I'm
Let
speaking into the mic.
Mr. Chairman, I want to save the Attorney General
Senator
from
Amin, 1
repeating
second.
an untruth.
Senator Amin, Senator Obika. 1 moment, please. Just let the chamber fall quiet for a few seconds. Right. Now, the Attorney General is responding. He is allowed to state observations that he has made. There's absolutely nothing wrong with that. I don't expect members to get riled up because the Attorney General is making an observation, nor, as I indicated earlier in these proceedings today, that we're going to engage in the kind of back and forth that would just lower the standard of dignity and decorum in this chamber. So you will have your opportunity to respond. You will do so succinctly, and like I said, just don't add the seasoning, it's not needed. And we will keep the process moving forward. So Attorney General, continue your statements.
Thank you, Mr. Chair. I was just proceeding to continue to say the law must have a line. There must be a consequence. The first part, Section 24, Clause 24, treats with liability of a controller in a very specific context. It's the falsity of documents, etc. That is something which ought to be an offense. The second aspect, which is the controller breaching and committing an offense in relation to any other offense in this act, it is necessary that we do provide those positions. The liability should be pinpointed to the person who has that responsibility, and therefore we've pinned that liability upon the controller. I want to remind that the controller is the named controller in the circumstances of the definitions clause. And when you're registering, you say who your controller is. If you are going outside of that definition, then you're going to what we call the real mind and functionality behind it. I do understand the position that I have observed from the opposition bench tonight. I am just simply making my observation of that at every point that we've had a clause-by-clause vote, the vote has been no from the opposition. I don't think I'm being untruthful when I say that. I recognize the submission made by Senator Obika, particularly as it relates to the solicitation clause, and as I've undertaken, and as is again an observation of fact on my part, we have treated with that in a very careful way tonight.
Senator Obika, just before you respond, just be mindful of the temperament. There's no need to get riled up. You can make a response.
I'm never riled, but I am glad for the guidance.
Enthusiastic.
The word I want to point to is two words, or recklessly. So whilst it may seem prudent when the wording in section clause 24, subsection 1 says a controller of a non-profit organization who knowingly, but then it adds or recklessly, all right? And I mean, really and truly, that is an easy catch-all.
No, it's not.
Which can mean anyone who makes an error, all right? Because reckless gives a wide range of interpretation. So I think if this part was drafted properly, we wouldn't have had this issue. But there's an issue with the drafting. So I think the Attorney General should take serious contemplation regarding this entire clause. It should not be there in the first place because it gives a catch-all and it gives the Registrar General a free hand to discriminate. And that is the issue that I'm having with this clause.
All right, Senator Hussain.
Thank you very much, Deputy Chair. Through you to the Attorney General, AJ, I understand what the intention of this clause is in terms of compelling persons through the imposition of a criminal sanction to file their documents on time, to file their documents when requested. But respectfully, when you go out to the consultation after the passage of the bill, I would like to suggest that something more proportionate be used, especially in light of the objectives of these NGOs. Why not, instead of imposing a criminal sanction, that something else be done in terms of an order from the court to compel these organizations to produce the documents? So we have instances of that in various pieces of legislation, so it's unprecedented. It's precedented, sorry. In terms of we change the method in which you try to compel these organizations to provide the documents.
Before you broaden it, it's important. It'll go too wide for me to answer.
Yes,
so would you permit me?
Go ahead.
I thank Senator Hussain for putting it into the context that he has, and I think that I can give him comfort. Well, but I must take a step back to Senator Obika. The Registrar General is nowhere inside of this in the context, in the manner in which Senator Obika raised it. Secondly, we're talking about offenses. The filing of documents on time is not an offense under this law. We just amended Section 17, Clause 17. There's an administrative fine for that. Apart from that, we have also specifically said the compelling is done by the FIU under 18G of the FIU Act. So you get notice, you're told to do this, the FIU tells you what to do, etc. So that again does not apply in the circumstances raised. But more than that, for an offense to bite, it's proof beyond reasonable doubt by the prosecutor having a burden to discharge. And then even more than that, there's the fact that this thing is not, it's far from trivial. Recklessness is not a pure mistake. Recklessness is a concept of law that has been well defined in the criminal law. So there's a very high burden, high hurdle, significant bar, and it does not capture the innocent or the innocent misrepresentation, the minor mistakes. It does not deal with late filing of documents. It does not have a divorce from the FIU's compliance and notice, etc. That is nothing of what this is about.
Senator Vera.
Yeah, just to reinforce what the AG is saying, because these offenses deal with false documents, and they're serious matters, considering the fiduciary nature of the controller. Recklessness is something that is well dealt with in the legal jurisprudence. It involves the knowledge or danger of risk and persistence in a course of conduct, which creates a risk that the prohibited result will occur. Also, even without these sections, we have an aiding and accessories and abettors act that could kick in here. There's a common law offense of conspiracy that could kick in here.
There's the Interpretation
and
Act.
attempts under the Interpretation Act that could kick in here. So this is just, I think, directing your mind that you have to be careful and that there is a consequence for engaging in this type of unlawful behavior.
Senator Mark.
Yeah, Mr. Chairman. We continue to close the spaces for the people's sector and their operators. And this is another manifestation in this particular provision, where the government is criminalizing NPUs. You know, sometimes I ask myself the question, but I have to go to the company's legislation to determine, Mr. Chairman, if profit companies in this country have similar criminal sanctions as we are imposing on ordinary people's organizations. And this, to my mind, is another manifestation of the government of Trinidad and Tobago seeking to close and reduce the spaces available for the non-profit organization, which is a people's sector and a people's institution. And under no circumstances, Mr. Chairman.
Senator, 1 second, Attorney General. Senator Vera.
Yeah, I cannot support this.
I understand Senator Mark's passion and his commitment and what he is really striving to prevent. I mean, he cannot be faulted for really standing up here. But the difference between what's happening with a non-profit and a for-profit company is that in a for-profit company, you have all kinds of already checks and balances built in. You have a board of directors that will have all kinds of very strict duties and consequences and obligations under the Companies Act. You have shareholders that will call in and call directors to account. But with a non-profit, you need to have these additional safeguards because people are handling money and they have to be, A, held to account, and there must be consequences if they do funny business.
Attorney General.
Just to answer Senator Mark squarely, yes, the Companies Act has offenses of a similar type, full stop. So it exists for companies that are limited liability or guaranteed by share or guaranteed otherwise, or all the multiple versions, externally registered companies, etc. So yes, the answer is just yes. There is fiduciary responsibility. There are liabilities attached to officers as opposed to directors, their shareholder issues, etc. I mean, that's just trite law. And I'm compelled, because people are listening to this debate, to reject out of hand the attempt to sensationalize what this law is doing. This is a very high bar that is being set, and there's absolutely nothing wrong in this approach, and I want people to understand that it is carefully measured.
Honourable Senators, the question is that Clause 24 now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 24 now stands part of the bill.
Clause 25.
Honourable Senators, the question is that Clause 25 stand part of the bill. Senator Vera.
Thank you, Chair. AG, the notices, a lot of these non-profit organizations, they have Facebook, they use social media. I was just thinking, why don't we include within the serving of notices email and electronic communications via social media and stuff? Because
Excellent suggestion, but need the physical copy as proof of service. Not that that's any guarantee. The fact is, sometimes the registry sends you a document, like the court registry or elsewhere, and you get it months later, and then you can deal with that because there's a stamp that goes with it. But what I can tell you, Senator Vera, is that on our e-platform, we are going to be doing this year the electronic notification to all entities. So that is part of the suite of services that we have purchased. The name of the company is Axial Group. They are bringing our new company server and whole IT platform up on deck, and that is going to be an experience that will certainly benefit Trinidad and Tobago. So we're doing that as well.
Okay. Honourable Senators, the question is that Clause 25 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 25 now stands part of the bill.
Clause 26.
Honourable Senators, the question is that Clause 26 stand part of the bill. Senator Mark.
Yeah, Mr. Chairman. Under Clause 26 of this bill, you have two sets of politicians being responsible for making regulations. You have the Minister of Finance making regulations. You have the Attorney General making regulations. This is a recipe for confusion. And I'm looking forward to the day when we will have what is called an NPO commission that is independent, non-interministerial, and directly accountable to the Parliament of the Republic of TNT. That is the day I look forward to, because clearly, Mr. Chairman, in the haste to bring this legislation here and not to be creative, as far as I'm concerned, the government has now burdened both the Ministry of Finance and, of course, the Attorney General's office with dealing with regulation. So one, Mr. Chairman, is a regulator, and the other one is an administrator. So confusion. So the poor NGO community will now have to look for two sets of regulations to govern their activities in TNT. I don't think that obtains for private companies, sir, or companies that are for profits.
Attorney General.
That couldn't be anything other than the thing furthest from the truth. Number one, the Minister of Finance is the line minister with supervisory function over the FIU pursuant to law. If Senator Mark felt that strongly about it, he had 2010 to 2015, 5 years and 3 months to sort that out. It was never done. Secondly, the minister with responsibility for the Registrar General is the minister with responsibility for legal affairs. In this particular incarnation, that happens to be the Attorney General, who has both portfolios. There is nothing wrong with this. It is trite law and parliamentary arrangement that this is how we do it. But more than that, yes, you're going to have to look for two different aspects, because the registry is one thing and the FIU is another thing. And to answer Senator Mark's position about whether for-profit companies fall into this category, yes, for-profit companies that are banks fall under CBTT, FIA, Financial Institutions Act, the Central Bank Act, the Insurance Act also provides a regime where for-profit companies, which are insurance companies, have multiple regulations to manage. And all of them have more than that when you're looking at the financial obligations regulations under the Proceeds of Crime Act. So there are umpteen examples where for-profit companies have to comply with 3, 4, 5, 6, 7, 8, 9 different sets of regulations. And Senator Mark ought to know that. So to make this allegation in this brave sort of way that he does has to just be rejected, because the facts are the furthest thing from the truth.
Okay. Honorable Senators, the question is that Clause 26 now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 26 now stands part of the bill.
Clause 27.
Honorable Senators, the question is that Clause 27 stand part of the bill. Senator Mark.
May I say again, the colonial mentality that we have in this country, where we have legislation dating back to 1906, and we are in 2019, I call on the Attorney General and the government to revisit this old anachronistic, outdated piece of legislation, which gives the Registrar General's Department power to make and to determine fees, to formulate and prescribe forms and other matters, and that these rules be made subject to a positive or affirmative resolution, so that the Parliament can have oversight over these matters and not continue with this old colonial hangover of 99 years, where the Parliament has been left out. I think the Parliament should be involved in supervising these provisions.
Attorney General.
I just reject it out of hand. First of all, the law is 1921, not 1906. Secondly, colonial laws serve us very well, the Exchequer and Audit Act. And you know what? The Constitution of the Republic of Trinidad and Tobago, which is the supreme law of Trinidad and Tobago, pursuant to Section 2. Thirdly, it is now the established practice around the world that instead of occupying Parliament's time for every single thing, that there ought to be a certain delegation of function, if I can put it that way, or a devolution of authority for minor matters such as these. And this has served our country very well. Our Parliament could barely keep pace with committees or with sittings. Other parliaments around the world do not draft laws the way we are doing now. Our very Parliament is anachronistic in many senses. So I just respectfully reject the argument coming from Senator Mark and stand with the position as enunciated by this bill.
Okay, Senator Mark. The question is that Clause 27 now stand part of the bill. Those in favor say aye. Aye. Those against say no.
No.
I think the ayes have it. Clause 27 now stands part of the bill.
Clause 28.
Honorable Senators, the question is that Clause 28 stand part of the bill.
I think you should let the leader suspend.
Yeah. Honorable members, at this point in time, I will suspend committee stage to allow the procedural to take place.
What to take place? Chair.
The Mark. Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, in accordance with Standing Order 14.5, I beg to move that the Senate continue to sit until the completion of the business at hand, inclusive of Senator Mark's 2 motions on the adjournment.
Read Mark's show, boy.
Honorable Senators, the question is that this Senate continue to sit until the completion of the business at hand, inclusive of the matters on the adjournment. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The business of the Senate continues until the completion of the business at hand, inclusive of the matters in the adjournment. Honorable Senators, we will now return to the committee stage. Okay, Honourable Senator, just please allow me to put the question. We're on clause 28 before we took the procedural. So the question is that clause 28 stands part of the bill. The question is that clause 28 now stands part of the bill. Those in favor say aye.
Chair.
Aye. Those against say no. I think the ayes have it. Hold on, Senator. Yeah, but that, apologies. It is my understanding that the clause 28 that you have proposed for an amendment is actually treating with new clause 28 as
Yes.
proposed by it. Right. So we do that after we dispense with all the
Sure.
original clauses of the bill.
Thank you, Chair.
So once again, I put the question. The question is that clause 28 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 28 now stands part of the bill.
Clause 29.
Honourable Senators, the question is that clause 29 stand part of the bill. The question is that clause 29 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 29 now stands part of the bill.
New clause 28.
Honourable Senators, the question is that new clause 28 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 28 will now be read a second time.
New clause 28.
Mr. Chair.
Attorney General.
Mr. Chair, we propose that a new clause 28 be inserted. Of course, the rest of the amendments we propose are really just the tidying up of numbers, etc. Yes. So as we call it 28, it's because we've consequentially amended, and we'll come to that in a moment, other positions. We're asking for specifically this clause to have reference to the Financial Intelligence Unit Act. We'll say, for the purposes of its functions under this Act, the regulator may exercise its powers under Section 831 and Section 8F2 of the Financial Intelligence Unit Act of Trinidad and Tobago to issue guidelines in respect of non-profit organizations. That's critical to tie into the amendment we made in Clause 4 to be abundantly clear that this tiered system will be managed by the FIU, that the FIU will cut the jacket to fit the different sizes of players in the industry. Now, specifically, Senator Drayton pointed out what he thought to be an anomaly, and I understand very well why, because the revised laws of Trinidad and Tobago are in the process of being done right now. We've done so many amendments that we don't have one compendium of laws. So I want to apologize that that has not been issued yet, but in particular in this Parliament, we've done with such rapidity so many amendments that we're fixing them. So the law as amended specifically, believe it or not, Act number 12 of 2014, that Act of 2014, the Act number 12 of 2014, amended the reference to properly be 18F. So I can give you the clarification that the amendment as noted by you, it's not 18E, it is 18F because E was amended to F because of insertions elsewhere.
Okay.
Thank you, Chair.
Initially, in reading the amendment, the Attorney General said 8F. So for the purpose of the record, I think we ought to be clarified that
Forgive me, 18F.
18F right
Yes.
through. For the, all right.
Apologies, thank you.
Senator Mark?
Mr. Chairman, I would like the Attorney General to advise us whether the guidelines to be issued by the FIU, whether those guidelines would be laid in the Parliament so that we will have sight of those guidelines, so that we will know what is taking place, what the FIU is proposing, or whether it would be kept a secret document.
Well, Mr. Chair, it's certainly not a secret document, and the guidelines are being issued in the same way all guidelines by the FIU are issued. So I don't know why it's all of a sudden something that's difficult. But let me just deal with the issue of secrecy. 18F2 says the FIU may from time to time issue guidelines as to compliance with written laws listed in subsection 1, which shall be published in the Gazette and at least one newspaper in daily circulation in Trinidad and Tobago. And I would like to remind that this particular amendment did not come from anybody else other than a UNC government in 2011 and then in 2014. Act number 8 of 2011, while the UNC was in government. Act number 15 of 2014, while the UNC was in government. So I don't know all of a sudden how a change from one side of the house to the other suddenly makes this secret and draconian and all sorts of things like that, Mr. Chairman.
I never said draconian.
There's no need to.
But we would still like it to be laid.
That's fine. So there's been the commentary between Senator Mark and the AG. Let me just invite Senator Drayton to make comments on your proposed amendments to this new clause 28. Senator Drayton.
Thank you, Chair. Given the update by the Attorney General, I'm satisfied that that change has been made, and I withdraw my amendment.
So withdrawn, Senator Drayton. That being said, the question is that new clause 28 be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 28 now stands part of the bill.
The schedule.
The question is that the schedule now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The schedule now stands part of the bill. Attorney General, just for a matter of cleanup, would you like to just notify honorable members in relation to the consequential amendments as you've put on the circulated amendments?
Yes, please. Mr. Chair, clauses 3, 6, 10, 16 as renumbered, 17 as renumbered, and 18 as renumbered require consequential amendments as a result of the acceptance of amendments which we've done already in the course of this committee stage. For the record, the government's rationale in proposing the amendments consequentially to clauses 3, 6, 10, 16 as renumbered, 17 as renumbered, and 18 as renumbered stand in that regard, and they are in the terms circulated.
Honorable Senators, the question is that the bill as amended be reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported.
Mr. Chair, sorry, before you do that, in having given the rationale for those consequential amendments, the Chair, I believe, would need to put that those amendments stand part of the bill. Could I be guided on that? No? Okay, great. Thank you for the clarification.
So I'll put the question again for procedural. No problem. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The bill as amended will now be reported to the Senate.
Mr. Vice President, I wish to report that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Attorney General.
Mr. Vice President, I beg to move that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters be read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters be now read a third time and passed. Those in favour say aye. Aye. Those against say no. No. I think...
Like that.
I want to let...
Mr. Khan? Mr. Khan?
Yes.
Mrs. Gopiskun?
Yes.
Mrs. Batiste Primas?
Yes.
Mr. Rambrad?
Yes.
Mr. Sadanan?
Yes.
Mr. Hussain?
Yes.
Ms. West?
Yes.
Mr. Lahan?
Yes.
Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Cummings?
Yes.
Mr. Duki?
Yes.
Mr. Samanat?
Yes.
Mr. Thomas?
Yes.
Mr. Young?
Yes.
Mr. Mark?
No.
Ms. Haynes?
No.
Mr. Amin?
No.
Mr. Hussain?
No.
Mr. Wika?
No.
Mr. Ramdin? No. Mr. Richards?
Affirmative.
Mr. Vera?
Yes.
Dr. Dialsek? Yes. Ms. Jonaran?
Yes.
Ms. Prasad?
Yes.
Mr. Timal?
Yes.
Mrs. Thompson-Nai?
Yes.
Dr. Dylan Remy?
Yes.
Mr. Triton?
Yes.
Mr. Vice President, the results of the division are as follows. 24 senators voted for, 6 senators voted against. 0 abstentions.
Honourable Senators, the results of the division are as follows. 24 for, 6 against, and 0 abstentions. The question as moved is passed.
A bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, I now beg to move that this Senate do now adjourn to Monday, 15th April 2019 at 10 a.m. During that sitting, we will be debating the Civil Assets Recovery and Management and Unexplained Wealth Bill 2019.
Honourable Senators, before I put the question on the adjournment, leave has been granted for 2 matters to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you, Mr. Vice President. Mr. Vice President, recently, the government, obviously acting with a majority at the National Flour Mill, through their board and management, took a decision to terminate the services of 4 general managers. This entire process that was conducted by the NFM to terminate the services of 4 general managers was flawed in that on the 15th of March, the general managers were advised by the chairman, Mr. Romano, and the CEO at a meeting held at the Hilton Hotel that they had decided, that is the board and management, board in particular, to flatten the organization by first eliminating the general manager, layers, with immediate effect. And Mr. Vice President, it is to be noted that no prior discussions was held with the general managers who were dismissed like animals. The SWWTU, which represents the workers at the National Flour Mills, likened the treatment of these general managers, 4 of them, as that of cattle and not human beings. Mr. Vice President, there is no structure in place to deal with the removal of 4 general managers. The principle of good industrial relations must always be observed, and action taken by the board and the CEO left a bitter taste in the mouths of those workers, and particularly the 4 general managers who were dismissed. Mr. Vice President, in an enlightened industrial age, there is no excuse for any missteps in the practices of good industrial relations and fundamental basic rights of all employees to be consulted in matters that may affect them. And therefore, the failure of the board and the CEO to treat these 4 general managers like cattle, thank you, cattle, like cattle, with respect to the dignity that they deserve and they ought to have experienced, speak volumes and should be condemned by all right-thinking citizens in our country. Mr. Vice President, what was this undue haste to eliminate 4 general managers immediately when there was no operational contingency plan? And why were these 4 general managers treated in such a cruel and unusual manner and not allowed any closure of outstanding company affairs? Mr. Vice President, the NFM have many highly paid legal consultants on their payroll, and we will expose them at the appropriate time. And there's already a legal advisor in the position of corporate secretary, and there's somebody in charge of IR matters. But yet still, Mr. Vice President, the same National Flour Mills has retained an IR consultant at very exorbitant rates, while they have an HR manager. And Mr. Vice President, they have an IR officer who is on full time within the company, but yet still they hire and pay for consultancy services. Mr. Vice President, whilst they have eliminated 4 managers, you know what NFM has done? They have advertised. I have the advertisements here, Mr. Vice President, where, for instance, in the Sunday newspaper, they claim that they're flattening the organization. They want to save costs. But here it is in the Express of April the 7th, 2019, on page 67, they are advertising for a manager for finance and accounting. And as if that is not sufficient, Mr. Vice President, in the same newspaper, right, on page 66, they are advertising for a manager for manufacturing. And that is before they employed a COO, that's a Chief Operations Officer. So the NFM is claiming that they have no money. Not they have no money, they are flattening, and they want to make the company more efficient, Mr. Vice President. But you know what? Why are they seeking to make the company more efficient? Is this the first step towards the privatization and divestment of the National Flour Mills to the financiers and friends of the ruling party? Is that the reason why they have acted in this manner, Mr. Vice President? So as far as we are concerned, on this side, we would want to ask, why were these general managers not offered alternative employment or a proposal made, Mr. Vice President, for the freezing or even the reduction of their salaries before the action was taken to dismiss these 4 general managers? Why? Why? Is it because of competence? Mr. Vice President, what is the reason? And therefore, they talk about they want to establish, as I said, a lean and cost-conscious and competent-based structure within the NFM. And that is why they have done that. So, Mr. Vice President, they have disposed of 4 general managers. They are advertising for 2. They have hired already 1 called the COO. So 3. So what is the objective? What is the objective, Mr. Vice President? Is it they are bringing these new managers to prepare the basis, as I said, and lay the groundwork, Mr. Vice President, for the privatization and the divestment of the National Flour Mill? We know in Trinidad and Tobago there is one major competitor in the industry today. We would like to ask the government, and we'd like the government to explain to this country whether the government's intention is to privatize and divest National Flour Mills. That is what we want to find out here this evening, Mr. Vice President. Because we know that National Flour Mills are a bit inefficient because of the fact that the government controls prices for flour at the retail level. So they cannot charge us the price that they want. And maybe that's a good thing because it keeps down the cost of living. But at the same time, Mr. Vice President, what is the game plan of the government insofar as the future of the National Flour Mill is concerned? That is why I've brought it to the attention of this Honorable Senate, so that the government could clear the air, because the talk in town is that the government wishes to privatize the National Flour Mills to their friends and financiers. I thank you, Mr. Vice President.
Minister of Trade and Industry.
Thank you, Mr. Vice President. And let me say the first sign of ill health in a company is in its financial statements. And if I look at the audited accounts of 31st December 2017, I see a decline in revenue. And I can tell you that this is substantially due to a reduction in sales of animal feed. It is also clear that there is a decline in the net profits in the amount of 16%. Arising out of that and also for other reasons, the National Flour Mills embarked on a 2018-2022 strategic agenda with the imperatives to achieve sustainability and profitability over the short, medium, and long terms by growth through expansion and also by adopting a lean, cost-conscious, competency-based organizational model. And pursuant to the above, a comprehensive job evaluation, and I say comprehensive, Senator Mark, and organizational review was completed in mid-2018. And the review revealed that the company's structure comprised excessive and non-value-adding organizational layers, including a tall hierarchical structure consisting of 11 functional areas, which was in existence, and also that the general manager layer between the chief executive officer and the substantive managers contributed to limited functional differentiation or value added. Further, this arrangement added significantly to managerial overheads of the company, and the managerial costs are high relative to the value added at the point of delivery of the customer. And an examination of the local manufacturing sector also revealed that such a multi-tiered or stacked organization is almost non-existent. And they would have looked at some local comparators like NP, SM Jalil, and VEMCO. And it is that the positions of general managers normally typify the top rung of the executive layer and 5 functional levels from top to bottom. That's the norm in organizations. So that in the light of the above, and particularly in the context of a very aggressive and competitive environment, the board of directors of NFM took the strategic decision to pursue an organizational strategy of delayering at the top level and upskilling from the bottom in an effort to create and sustain a lean and more cost-effective organization. Can I inform that the benefits of delayering are many? That kind of strategy places leadership, competence, and the resultant value creation activities much closer to the points where value is actually created. Also, a flatter organization structure facilitates both communication and shared conversations and shortens the distance between decision and execution. And the resultant consolidation and harmonization of former silo-type functions at NFM will now allow for the coordination of complementary work processes as opposed to the previous arrangements. NFM will measure the benefits of the restructuring in terms of reduced management overheads, improved productivity and profitability, improved employee satisfaction, and improved customer satisfaction. I want to say that the Ministry of Labour, Small and Enterprise Development also looked at the proposal along with the Ministry of Trade and Industry and also the Minister of Finance. And the Minister of Finance would have granted approval for NFM to implement its restructuring plan. It's important to note, especially with the allegations raised by Senator Mark, that at the unionized level, the process of upscaling will commence with a competency assessment exercise. So this is a competency exercise to begin from the bottom, upscaling all of the employees. The union and workers have been engaged and will continue to be a part of the process of competency evaluation and assessment during 2019. Staff will be given development plans as needed, and the organization will ensure the appropriate training and development takes place. And at the end of the day, let me say something about the separation packages, that NFM did in fact adhere to established industrial relations practices in making the positions of general manager redundant. And further, the managers are being paid salary and allowances during the notice period, which ends on April 30th, 2019, as outlined in the terms and conditions of the existing contracts of employment. And following this, all termination benefits, severance payout, and pension benefits will be paid to the affected managers. and as such, the managers are being given comfortable separation packages. And it's important to note that the 4 positions were not a part of a recognized bargaining unit. Let me say as well that the divestment of NFM to the private sector is not under consideration by either the government of Trinidad and Tobago or the board of directors of NFM. You asked the question, where is NFM going? Now, the company is required to be as lean as possible, with a focus of diversifying the business into the production of other types of foods and agricultural products. They are this time also pursuing its SQF Level 3 certification. That's a quality certification, and they're going to complete that by September 2019. The employee training and uptraining will continue, and retraining will continue as well. The deliverable, main deliverable is a quality product to the nation and also for export. But they must improve productivity and also reduce their operational costs. So, Mr. Vice President, there's absolutely nothing sinister about the way this has been done. It has been done, as I said, in the proper manner and in line with good industrial relations practices as well. And the member, Senator Mark, also raised a question about the manufacturing manager. And yes, they are in fact recruiting a manufacturing manager to oversee the food production, the feed production, and the maintenance functions. And they have already replaced the departing general managers with a CEO with responsibilities for manufacturing, sales, and marketing and information technology. I'm quite satisfied that NFM is on its way to being a lean organization. And I emphasize that the government has not been looking at any divestment of NFM, and has not been entertaining any discussions with any members of the private sector at all. I give everyone in this August chamber the comfort of knowing that NFM is on the right track. Several times in the life of an organization, this is what is necessary to ensure profitability and also whatever they do in the best interest of their employees as well, always taking them into consideration. So it's a good future ahead for the NFM. Thank you.
Senator Mark.
Mr. Vice President, over the last few months, particularly the last 3 months, motorists have been complaining about the quality of the fuel being used and being purchased by Parliamentary Trading Fuel Company, which supplies fuel to NP, and in turn, NP supply the fuel to their retail outlets. And whilst Parliamentary Fuel Trading, the National Petroleum Company, even Unipet, have been making statements to the effect that the fuel that is being imported by Parliamentary Trading Fuel Company Limited is of a higher quality than that was produced previously by Petrotrin. Nevertheless, Mr. Vice President, the complaints from the motoring public and population continues to flow into the various areas of our country, whether it's social media, whether it is the national media, or whatever medium of communication. People are concerned about the quality of the fuel that is being supplied to National Petroleum by Parliamentary Fuel. Now, recently, the situation became so severe and grave, that is the amount of complaints, that National Petroleum Chairman Shahid Hussain indicated that NP will make an attempt to conduct an independent test of the fuel supply in order to reassure the national population. But this is what they have been doing, because they do have, from my information, certain systems at NP to test the fuel that they receive from Parliamentary Trading Fuel Company. And Parliamentary also, when they import in their fuel from different sources, they too have systems in or at point of peer to test the fuel that they are importing. And they too claim that the fuel is of a high quality. But yet still, Mr. Vice President, the population continues, that is the motoring population, continues to complain about the low quality of fuel supply, of fuel that they are in receipt of when they make their payments at the pump. So, Mr. Vice President, in an effort to get to the bottom of this, because people were not complaining when Petrotrain was alive, but now that we have fuel coming from different sources, and Mr. Vice President, because of the absence of transparency, we don't know if it's coming from Venezuela, we don't know if it's coming from Saudi Arabia, we don't know if it's coming from Nigeria, we don't know if it's coming from the United States, because there's absolutely no transparency and accountability from that company called Parliamentary Fuel Trading to the population as to where it is importing fuel in Trinidad for the Trinidad and Tobago market. So, Mr. Vice President, I think that the time has come when the population must get some answers from the government. And while the Bureau of Standards has its work to do, and whilst Parliamentary Fuel is testing and confirming that the fuel is of a good quality, and whilst NP is also saying the same, the population is not supporting their positions. That is what is being communicated to us and to the public generally through the medium of the newspapers and the communication network. So what we are asking and what we are requesting is for the government to really take a real serious objective look of this particular question of the quality and the standard of fuel that we have been importing. We need to have, Mr. Vice President, an independent group to test the fuel that we are consuming as motorists in this country. And I'm not talking about the Bureau of Standards. And I'm not talking about Parliamentary Fuel conducting their own tests. And I'm not talking about NP going and conduct their own tests. We need to get, Mr. Vice President, to deal with this matter once and for all, an independent outside team of experts to really conduct an objective test on the supply of fuel. Because the claim is that the fuel that we are consuming is burning faster than what we used to experience in the past. And therefore, if it is burning faster and you're getting less per mile in terms of consumption of gasoline, Mr. Vice President, it means to say that the ordinary people, whether you be a member of the middle class or you're a member of the working class, with this brutalization that we have experienced and oppression under the PNM for the last 4 years, you can understand, Mr. Vice President, that people have to dig deeper into what is coming shallower and shallower pockets in order to pay for fuel. That is really cutting down rather on their disposable income. And therefore, it is absolutely necessary for the government of Trinidad and Tobago to take heed of the advice or the views that are coming far and wide on the quality and the standard of fuel that consumers who have vehicles are complaining about. And I would like to suggest to the Minister of Energy and Energy Industries that we may have to look to get external independent experts to really look at this question of the quality of fuel supply in Trinidad and Tobago. And I think that when I speak today, I speak on behalf as a driver myself, using fuel. I myself have observed the consumption rate being rapidly, you are not getting the mileage, Mr. Vice President, that you used to get in the past. And therefore, the fuel is burning faster. So I speak on behalf of the motoring public in Trinidad and Tobago to get some answers from the government on this entire question of the quality of the fuel that we consume in our motor vehicles that is supplied by Parliamentary Fuel Trading. The government needs to take steps to reassure the population that they are not buying cat in bag and they are not being ripped off by the government through the supply of gas from this company called Parliamentary Trading Fuel Company. I thank you very much, Mr. Vice President.
Leader of Government Business.
Thank you very much, Mr. Vice President. So, Vice President, since this government decided to restructure and retool the operations of Petrotrade by ceasing refinery operations at Point-a-Pierre, there are those in this country, spearheaded by the UNC, who wished everything would have gone haywire. We promised the country at that point in time three things. There will be a seamless transition in the supply of liquid fuels, LPG, and bitumen. That has happened. Everybody said there will be shortages of this, shortages of that. There has been absolutely no shortages. The Parliamentary imports liquid fuels. Liquid fuels is an internationally traded commodity. The first contract went to BP Trading to supply. For those of you who visit the United States, the BP service station sells more expensive than everybody else, because their quality is good. BP has been supplying. Most of our products come from the Gulf Coast of the United States. That's where the big refineries of the world are. We import RON 92, RON 95, and diesel. RON means research octane number. Octane number is the compressibility and combustion quality of the fuel. So if you buy RON 92 from BP Trading, you're buying RON 92. You're not buying some lower RON. When you're buying RON 95, you're buying RON 95. All Parliamentary Cargo's products are fully tested at a load port. That's before it is shipped. Where it is loaded in Louisiana or Texas or Oklahoma, wheresoever, it is tested there. On reaching Trinidad, there are laboratories at Garacara that does testing. Testing is in compliance with the Trinidad and Tobago Bureau of Standards, the TTBS specifications for motor vehicle fuels. Independent inspector companies do the testing. It's not Parliamentary. Some of these are called Seabolt, SGS, Camin, and Amspec. Those are locally operated inspection companies that do the testing. Invariably, all Parliamentary fuels meet the standards of the Bureau of Standards or surpassed it. There has never been one instance where the quality was less. But people's mind have been conditioned to think a particular way. Within a month of importing fuels, there was this rumor going around that the fuel was burning faster. A month before, too. Good? Even when, let me give you the story. Paria had Petrotrin stocks for 30 days. So even though we announced the importation of fuel, at the point in time when the rumor started that the fuel were burning faster, it was Petrotrin's fuel. The same fuel they have been using for donkey's years, you know, because that was part of the inventory of the refinery. And that rumor spread. Unsubstantiated. And that has died down now. Next thing you know, somebody didn't maintain the vehicle properly. A fire catch. They blame it on the fuel, you know. From a mechanical engineering point of view, fuel combustibility and run has nothing to do with the burning up or a vehicle catching fire. It has to do with a leak in the system. And again, it is people have been conditioned to want bad things to happen to Trinidad and Tobago. And I resent that because it is being fueled by this front bench. So I just want the population to understand that the systems are in place. There's nothing wrong with the fuel. The fuel is being imported by reputable traders. The fuel is being handled by Paria. The fuel is being sold onwards to Unipet and NP, who are the retailers on the license, and they distribute fuels to Trinidad and Tobago. There's absolutely nothing to worry about, and all this old talk about it burning faster, your car catching a fire, all that. I don't want to use the word fake news because I'm fed up hearing it. It is untrue, and it's unsubstantiated in science and in fact. I thank you, Mr.
Honorable Senators, the question is that this Senate do now adjourn to Monday, the 15th of April, 2019 at 10 a.m. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Monday, the 15th of April, 2019 at 10 a.m.